Hey, what's up, y'all? Just making sure I jump into this as quickly as possible. It's going to be long, so just prepare to stay with me for a while. I'm back on SNKRLAW. Those of you who have been following, it's not a lot of views on the SNKRLAW videos, but there should be. I don't know why you guys aren't watching them, but I only have 3,500 or 3,400 subscribers. I guess when I get more, people will be really in tune to what I'm doing, and this one is going to be very long because everybody's talking about it. But instead of just talking about it, what I wanted to do was come back because I was reviewing SNKRLAW, right? Make sure you guys know that's Anand and Goldstein. I'll put the link to purchase the book. This is not an ad for them. I'm doing this because I'm super intrigued by the book. I'm more so intrigued now because, as you all know, what happened yesterday. But this is what always surprises me about all of these sneaker websites and the people who claim to be these sneaker people. Research is critical, man. Just because we are in sneaker culture, I'm on chapter 7, and it's the law of sneakers, part 1, the law and litigation. I don't want to read everything here, but this is so doggone timely that I don't have a choice. So those of you who are willing to deal with this video that's going to be very long, I thank you guys for dealing with it. And I'll be breaking off, I'll read, and then I'll break off, and I'll read, and I'll break off. But the reason we're getting into this is because yesterday you had all of these people doing videos on the Air Jordan 1. And the fact that Nike filed this USPTO. Well, I'm on the USPTO website. So when you look this way, over here to the side, you can see that I'm on the USPTO website. More importantly, you can see Nike Inc. Instead of me sitting down and just doing what everybody else is doing, which is copying and pasting and saying Eric High is in trouble. What I want to do is make sure you guys are a little bit more equipped to recognize what's about to really happen. There have been 774 trademark applications, not just one for the Jordan 1. Everybody's kind of looking at the Jordan 1. But here's the intriguing thing. Remember the Hinder scheme Jordans? I'm going to show you something really quickly here. And this is a Solomon ad. I'm going to scroll down and start looking at the different patent applications. And I'm going to start here and show you guys all of the trademarks that have been filed. Now, that automatically makes this video much different than everyone else's. What makes it more different is I'm using the SNKRLAW book from Anand and Goldstein, and I've been covering it this whole time, but now it's more relevant than ever. So I'm going to pull back and I'm going to go ahead and read it. And I know they're like, Chris, don't read the whole chapter. Sorry, fellas. Probably going to read the whole chapter. In addition to excellence and courage, I'm going to skip that page. That's a quote from Hillary Crane. And now a word from our authors. I'm going to skip that. And I'm going to go right over to most sneaker companies, whether big or small, is where we should be. And we're looking at intellectual property. And that's why we're looking at what's over here to the side. Most sneaker companies, whether big or small, have lawyers who oversee many of their essential legal tasks. Their work can make or break a project. When your favorite athlete or celebrity gets lucrative sneaker deal, lawyers on both sides will draft and negotiate lengthy legal documents. Now, brands looking for every edge in the lucrative and competitive world of kicks can find themselves in court calling foul on a competitor or defending their latest edgy move. Now, they get into a breakdown in chapter 2 of SNKRLAW, but we get to the intellectual property page. And we're going to say the law and litigation with an overview of intellectual property law in the United States, which we believe is the most crucial component of the law of sneakers. What is intellectual property? According to the World Intellectual Property Organization, intellectual property refers to creations of the mind such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. These laws are designed to encourage innovation and grant certain protections. Now I'm flipping over and going straight to trademarks, and that's where we are in this section. And then we're going to scroll through. I might not make this as long as I said I was going to make it. A trademark. So they give us a breakdown of the different forms of these categories. All right. So trademarks and trade dress, copyrights, patents, and trade secrets. So trademark is like the brand Li Ning. Trade dress is the visual appearance of the Adidas superstar. Copyright is the stripe pattern on the Yeezy Boost 350. Patent Nike's Flyknit technology, which we know had a battle with PrimeKnit. And that's an interesting discussion, but we'll come back to that, maybe, maybe not. Trade secrets, proprietary confidential brand secrets and methods used in the creation of, for example, New Balance sneakers. Some countries and regions such as the European Union have other types of protection that are not covered in this book. You have a history of trademarks that they get into, but the main thing is they start talking about the Lanham Act. And I'm sorry about things going out of focus, but trademarks is a service. A trademark or service mark is any word, name, symbol, or device used to identify and distinguish one manufacturer's goods or services from another's and to indicate their source. A trademark applies to goods and a service mark. Now, we can keep going through that, and we know that trademarks can be names such as Nike and Reebok, slogans, just do it, or even the logos and Adidas stripes. So he gets, Anand and Goldstein get very deep into this section, and they talk about the Lanham Act. What does the Lanham Act do? The Lanham Act is a law designed to protect trademarks in the United States, but what it does actually do, the act governs trademarks, service marks, unfair competition. It sets forth, among other things, what a trademark is, what kinds of acts constitute trademark infringement. Important stuff for the Lanham Act, Lanham, L-A-N-H-A-M Act. All right, so let's move on to this page. What constitutes trademark infringement? And then we're going to scroll. I won't make this a 30-minute video or something. We're going to scroll through and look at all of the designs that Nike just put in for a patent, or not a patent, but a trademark application. Because if you're simply looking at the Jordan 1 and you haven't done your own research, well, use my research. I'll put the link in the description and you can go through and check that out. Make sure you guys pick up this book, man, because it's just perfect. It's timely. I can't stress how timely it is. Lanham Act. Infringement of a registered trademark involves the use in commerce of any reproduction, counterfeit, copy, or imitation used to sell, offer, for sale, distribute, or advertise goods and services that are likely to cause confusion, mistake, or to deceive the consumer. I was just talking to one of my homies who's creating a shoe that was similar to that Air Kai shoe for his own brand for promotion. You can't do that. So he was like, well, I can still create it and just put my stuff on it and use it to promote, even though I'm not selling it. Nike can come after you for doing that as well. All right, so bruh, don't do it. I'm not a lawyer, so don't listen to me in that regard. You know what? Reach out to Anand and Goldstein and talk with them. I'm sure they're going to charge you, but reach out and talk to them. And maybe you can, but I wouldn't risk it, man. Start designing your own stuff. How does one demonstrate trademark infringement? The holder needs to show two things. They must prove that they own a valid and protectable mark, which is what Nike did by applying for the USPTO trademark, right? They must also demonstrate a likelihood of confusion, that a consumer will likely be confused about the nature or origin of the product or service. And we remember this from the Warren Lotus dunk and how he got sued. And is this stuff going to be hard to battle? It doesn't matter that it's hard to battle. It only matters that Nike has more money than you, and that if they litigate you and they initiate a battle, can you afford to be in court with Nike for 6 to 9 to a year, months to a year? No. I don't care who you are. You're not big enough to stay in court with Nike, who's almost a $50 billion company. You can't beat them. So design your own stuff. We can keep going into this section and we'll talk about registered trademarks. Is trademark registration necessary? Registration and protection of trademark in the United States. How to protect trade dress, notable trademark and trade dress cases. Like I said, I need to sit down and go through all of this different stuff, but they actually go in detail into the Adidas 3 Stripes thing where they had the Payless imitations, right? Extremely good book. Like I said, super timely. The lubes, right? And Yves Saint Laurent, lubes and Yves Saint Laurent. Let's take a pause real quick, and we're going to come back to it. And now we're going to get into the Nike USPTO and trademark stuff. Adidas versus Skechers. I forgot about that one. Awesome book. 1 second. So we're jumping back into it. I'm sorry about that little short break, but I had to stop for a second. We have the Converse versus ITC. this whole section, you see how thick that is? This whole section takes you through a lot of the battles between the companies that have had trademark infringement and copyright infringement issues. One of those I mentioned a few minutes ago was the PrimeNet versus Flynet battle between Nike and Adidas, and that's here in the book as well, man. Once again, the guys have sat down and completed one of the most official books that you can find. Once you can pick up SNKRLAW on the website. It's down here in the description. You can grab it. That's up to you. I am not advertising. I'm simply using them to get into this discussion on Nike Inc. And I know somebody's like, hurry up and get to that scrolling that you were about to do. And I'm about to. The chapter finishes up with employee rights, but also employment contracts and letters, offer letters. And that's a lot of very important stuff. But this chapter 7 is very, very long. And it's a very important section. Very important section, man. And I'm sure a lot of you guys are like, here are the patents, the patent information on the mag, right? And I know we lose a lot of light when I do that. I apologize. But the patent information for that, the patent information for the Yeezy. A lot of information in this section. And you got these notable, it's actually copyright. I kept saying patent, but I was in the wrong section. It's the notable copyright cases. So copyrights versus trademark in that regard. I apologize for that. But once again, if you bought the book, then you know exactly what I'm saying. I'm not doing a live stream, so nobody can be like responding right now. But let's get to the most important. That was chapter 7 of SNKRLAW. Super important book, man. I think everybody should have a copy. If I was still teaching and I was doing business writing, I would have at least a 4-week section on this book for business writing, in particular with sneakers. I just do that if I was still teaching any college courses. It's that good of a book. Let's get over to our Jordan discussion. So on every major website right now, there is Jordan 1 is being protected. And like I told you guys, if you come to the USPTO, I love clay. That's why it's showing up in my ads. But I'm wearing blazers today. So Nike, don't get upset. I'm wearing blazers today. There we go. And dance socks and Rough Feathers clothing, Memphis based. My bad for deviating. Get back to it. Patent applications, okay? So we can go down here and we can start looking at digital fingerprinting, treadmill with vertically displaceable platform. All of the different ideas and concepts that Nike is working on, they are going in deep and they're fouling for trademark protection, and rightfully so. There are so many new companies jumping up now utilizing Nike as a I even did it. I'm not even going to sit up here in front like I didn't do it. When I made my first shoe, my second brand, Arch, I actually used elements of the Air Max 90 and the Nike Free. We all kind of do it as designers, but what you have to do is start pulling away and saying, okay, I'm going to use this as my basis, but I'm going to learn from it and I'm going to do my own thing. That's the best way to protect yourself, man. If you incidentally or accidentally use something from a previous model and you can prove that you didn't know, obviously you have a chance to stand up against Nike. It's just going to be so damn hard to protect yourself. But as we go down through this list, we're looking at 524, which is just last month, 426. Starting here, all of this is right now. The Jordan 1, as we start moving down, bam, 7/31/2020. So it took a year, almost a year, but it is officially a trademark now. And there's the Jordan 1. But you guys do notice live application published for opposition, and you can go in and fight against it right now if you want to. But you're not going to win. We all know that this was the first shoe of its type. It's why it's such an important shoe in sneaker culture. But that's not the thing. What you guys need to recognize, man, is they're doing the outsole for the Air Max 90, the upper for the Air Max 90. They're protecting themselves on every front. The Foamposite, Jordan 11, Jordan 4, Jordan 5, Jordan 3, Bo Knows, Next Nature, Jumpman, Nike. Dude, Nike is like, you know what? We're done with you. Y'all guys are not going to sit here and take our most popular silhouettes and keep making money off of our product. It dips into our pockets. We're coming for that ass. You're in trouble. So stop doing it. But you see the Flight logo. There's a lot that they're doing right now. The low cut. And see, and this is the funny thing. Everybody's looking at 731 for this one, for the Jordan 1, but nobody's talking about the fact that the Jordan 1, the OG low, and the OG, not the OG, but this is the Air Jordan 1 low. This is the Air Jordan 1 low OG. Those could also be kind of utilized for the dunk as well. But dude, Nike is protecting themselves now. They are in full force like, yo, you're not going to move over and do the Jordan 1. You're not going to sit down. You're not going to copy this stuff. You're not going to bite our ish. Stop it. This is what Jordan said on that one commercial. Stop it. Just stop it. It's an extremely interesting discussion. We all know what's happening here. If you stayed this long, I appreciate you guys for staying this long. I actually had a coupon code that I was going to give away right now, so whoever used it, I didn't bring the card with me. I'm over here at the studio and not at the crib. I left it at the crib. I guess that's it, man. I'm going to cut this one. That's almost 18 minutes. If you stayed this long, thank you. I appreciate it. You know what? I got a size 14 blazer. The first person they can show me they actually bought a copy of SNKRLAW that writes me. The person that gets to the end of this video, if you wear a size 14, I got a size 14 Move to Zero blazer. It's black with the wool, recycled wool. If you can show me that you have a copy of this physical in your hand, some kind of way, email me a picture or something. I don't know. That shoe is yours. I'll even pay for the shipping. So that's my giveaway that I've buried at the end of this video if you made it this far. I appreciate you guys, new subscribers. Chapter 8 is coming up. I'm going to get back to doing the book. I'm going to finish it up. Once again, SNKRLAW, Anand and Goldstein. The link is in the description. I hope everybody's doing well out there, man. And Nike's not playing. Nike is not playing. This is it. It's getting real, son. Nike. That's it. Let's wrap this up. I'll see you guys on the next one. Once again, appreciate you all. Hopefully this was informative. Oh, the Giannis logo. That's 7/8/2019, so that's already done. So, oh, these are older, obviously. 1/31/2020. Blue Ribbon Sports. They hadn't done Blue Ribbon Sports until last year. Oh, they have to redo it. Okay, you have to redo it. I said I was finished, didn't I? I'm still talking. I'm just amazed at this stuff. I'm putting this link down here so you guys can go to it. Because this is, everybody's sitting up here talking about just the Jordan 1, and nobody's talking about the fact that they've done all of these joints. The most popular models, dude. Man, Hinder Scheme. There's a new company that I just saw, man, had a shoe looked exactly like the Jordan 3. Wow. Better get the designer. Peace, y'all.